Welcome to the Top Texas Lawyers Podcast. This podcast is brought to you by the law firm of Abercrombie and Sanchez, PLLC. You can find us on the internet at astxlegal.com or by calling 1-888-981-7509. Your hosts are Bryan Abercrombie and Samuel Sanchez. Bryan has been practicing law for 18 years and is board certified by the Texas Board of Legal Specialization in the area of family law. Sam has been practicing for 13 years, is licensed in both Texas and Florida, and is a certified mediator. This podcast is for informational purposes only, and all views are the opinion of the hosts. It is not designed to provide legal advice for your particular legal matter, and it should not replace the advice of competent counsel. Welcome, and we hope you enjoy the Top Texas Lawyers Podcast. Good afternoon, and welcome to the Top Texas Lawyers Podcast. I'm your host, Bryan Abercrombie, and with me, as always, is my co-host, Samuel Sanchez. Sam, how you doing?
Doing great, Bryan.
We thought we would change our topics up today a little bit, and instead of talking family law, let's talk a little bit about a matter that's related to family law, but it's not family law, but it deals with your family. It's wills and probate and estate planning, and why that's important. We always start out our show with some celebrity tidbits and different information about what's going on in the news. So Sam, I'll let you take it away.
Sure. Let's talk about the hand of death, unfortunately. We've had some passings in the entertainment world, and I think they kind of play perfectly into our conversation today. Starting off, let's talk about Eddie Money. I don't know if you guys remember Eddie Money. Hopefully you do, Bryan.
But, oh, yes, I do.
I'm going to take you home tonight. Great song. Eddie, he definitely had some great tunes, had a pretty prolific, singing career, had quite a few hits. He passed away recently from his bout with cancer. And in that, for him, it seemed like at least this was something that was known to him. He'd been battling esophageal cancer, which doesn't sound great. But he'd been battling it for quite a while. So this didn't come as a surprise to him and his family. He'd been married for a long time, since 1989. They had 5 children together. And so, a lot of times, as we're going to talk about going forward, this is your chance while you're alive, before you get sick, to kind of lay out some things that you want to do to preserve life as it exists for your family going forward.
And Eddie was, like you said, it was one of the things we're going to touch on is, what do you do for planning before you die, and what do you do after you die? And really your estate plan is really for those, for you, to make you comfortable, and for those that are left after you. So what other notable celebrities we want to talk about?
Sure. Most recently we have, Ric Ocasek, and I don't know if anybody remembers the Cars. I know I'm going back into my life in the 80s, but these were great bands, great songs. Yeah, they were fantastic. And Ric Ocasek, obviously he's probably most famous, one, for his songs, because he had tremendous, quite a few hits, but he married Paulina Porskova. And I don't know if you remember.
Oh, yes,
Paulina.
I do. Swimsuits, Sports Illustrated.
I think every kid, at that age from, let's say, 9 to about 95 knew who Paulina Porskova was. She was pretty gorgeous. And Rick, Rick was a great singer, looking, but singing, fantastic.
He gave us all hope, Sam.
He did. He made us believe that there can be miracles. There are these gracious moments where beautiful women will choose to be with us.
And if I remember correctly, Rick had 3 marriages, and then he had 6 kids, so 2 from each marriage, if I remember correctly.
Exactly. So, in this, it presents the kind of different complexities that we'll touch on today as well. Blended families are just a fact of life. Very rarely are you running into more and more families that have stayed together for years upon years into the, latter part of their life. So as a blended family, wills and the packages that we're going to talk about, potentially trusts, pour-overs, and these type of documents that are going to help preserve life for your family are going to be really important, especially in that situation where you're trying to say, hey, maybe this I want for children that were born to a previous relationship, or even out of wedlock. So these are going to be things that are really important. We'll touch on.
And then we had a notable death from the 90s with one of our favorite TV shows as high school and college kids, Beverly Hills 90210. Can we talk about that one?
Oh yeah, my man Luke Perry. I tell you what, I can't tell you how many times I tried to make my hair look like his. The guy could wear some chops.
He sure could.
And this was a guy who, again, multiple marriages, had children from different marriages. He was in the process of getting remarried And, most specifically about him, again, another cancer victim, which is terrible. Hopefully at some point we'll find a cure for that disease. But it was really important to him as he was going through this. It ended up happening that he had an early screening in 2015 that revealed some precancerous growths, ended up being the reason that he passed away. But I will tell you that scare, it created the opportunity for him to seek an attorney who went in, created a will, and really he or at least his estate references that as really important to him, that he was able to kind of preserve things and take care of his children in the manner in which he wanted to because of that will.
And that allowed him to pass, things in his estate directly to his children with, and I don't want to say skipping his wife, but making sure that the gift or what he wanted to bequeath to his children actually got to his children. And that's going to be one of the things we'll touch on in this discussion. And one of the other notable deaths I can think of this year was fashion icon Gloria Vanderbilt, whose son is Anderson Cooper on CNN. I remember my sister wanted a pair of Gloria Vanderbilt jeans like nobody's business when I was a kid.
Oh, heck yeah. I mean, those are quite the rage. And you know what? I mean, she built a huge empire, for her family, and things like that. Obviously, the Vanderbilts, very famous in American history for their wealth. Wills and the documents that we're talking about is really a mechanism for families to be able to preserve wealth from generation to generation. And that's an important thing to a lot of people, whether you have a lot of stuff or a little stuff. Making sure that it gets in the hands of the people that you want is really the things that we're going to talk about a little bit today.
So let's and you don't have to be Gloria Vanderbilt or Luke Perry or have a huge estate to need a will. I mean, you just have to own property, or you just have to have something that you want to leave to someone else. Let's talk about the basic estate planning documents in Texas, because we're talking about Texas law. So let's talk about what we basically have here in Texas.
Sure. There's a couple of things that I would recommend that everybody have on file in advance of a will, or really accompanying a will, but we'll talk about these first. One is a durable power of attorney. Okay. A durable power of attorney, no one can predict the future. No one knows how their life will end, when it will end. You can look on the news or listen to the radio or one of our reports and see that, a lot of these deaths weren't planned for. Eddie Money, he saw it coming for a long time. He'd been battling cancer. Well, Luke Perry had a stroke as a result of things that were going on in his body that he didn't know. It's very quick. So in that situation, as you look at it and you prepare for your family, a power of attorney, what it does is it affords somebody the opportunity to say, if I'm ever incapacitated, a simple example, it's in the news right now, Bryan, is, what's going up in the upper Northeast, Michigan and in those states, we have, mosquitoes running around, this mosquito-borne illness, this triple E encephalitis. It's killing people in, a couple of days. And it's not like you're going to be outside thinking, hey, it's a beautiful evening, I'm going to throw the ball with my son, or, chase my daughter around, in the backyard playing with bubbles, and you get bit by a mosquito. 2 days later, you're in the hospital and you're passing away. And, in that, even if you don't pass away, let's say they just put you on a respirator, you're not able to make financial decisions. What a statutory durable power of attorney does is it affords someone else the opportunity to make legal decisions for you that need to be made. Potentially maybe selling property or making withdrawals out of accounts, those kinds of things.
Yeah, and let's talk about the differences. There's a durable power of attorney that deals with healthcare matters, and then there's one that deals with financial matters.
That's correct. So, in the financial section, let's start on that first, this durable power of attorney. It's going to be something that you're going to want to talk to an attorney about because it has long-lasting effects. These are typically going to be in effect until revoked. And it basically creates an agent relationship. So your agent is going to be able to make decisions for you financially, legally, up to and including buying, selling real estate, opening and closing bank accounts, credit accounts, those kinds of things. So basically anything that you could do financially, you're giving them the power to do. Now, in these, you can be creative. You can craft certain, you can name multiple agents. But two, you can also say, well, I want them to be able to do X and Y, but potentially I don't want them to be able to maybe sell real property. So it's really important that you talk to an attorney to help carve out this document while you're sentient, while you have the ability to kind of think clearly. Because once you get to a hospital, once you're already, that comes in question, these documents are very difficult to get. in
And
place.
one thing I hear a lot from clients is, oh, well, I have a will. Oh, well, I have a will. Well, the will covers you after you die. But these documents that Sam's talking about, they don't cover you. They cover you before you die. So let's say you're in a coma for 6 months, or let's say you're in some kind of a state where you can't make decisions for yourself. This is where powers of attorney become critical. And like Sam said, you can cross out the powers that you don't want your power of attorney to have. So if you say, I want them to be able to spend money and pay my expenses, but I don't want them to be able to sell my house, you can certainly make that part of your directive. So, and keep in mind, you can, let's say you come out of the coma and you're fine, you can revoke that power of attorney anytime you need to.
Agreed. And not only that, but I try to tell people, going through, let's say you're going through the divorce process, you have to remember that these types of documents, they're one, because, everybody gets worried like, well, I don't want them to just have this power forever going forward. Can I change it? Yes, you can. What types of situations are going to automatically revoke these types of statuses? A divorce is one of those, where you're not. So if you think I've had a will, he executed it when I was married. I've been divorced since that time, but it still has these agents designated. You still have to update these documents. They are living, breathing documents throughout the course of your life.
Okay, let's talk about the directive to physicians.
Sure. So a directive to physicians basically says the types of treatment that you're going to be willing to endure to sustain your life should it become necessary. A lot of people say, I don't want to be put on a ventilator. If I'm brain dead, I don't want my body just staying around so that my family has to endure these huge medical bills or the pain and suffering that encompasses a situation like that. The directive to physicians basically says, these are the things that I'm going to allow you to do to sustain my life or not do. Don't put me on a ventilator. I don't want to be force fed through a tube. I want pain medication to be administered to help ease my pain, my last days. These are the kinds of things that you can absolutely put in place before it becomes necessary so that there's no question. Think about the pressure that you save from your family, Bryan, in that situation where instead of them having to make a very difficult decision, you made it. It's your life. It's your body. You got to put that in place and take that pressure off of your family.
Yeah, that's just what I was going to say. Is it's really for the people that have to make the decision. You're sparing them the difficulty of having to make a life and death decision concerning you because you've already taken care of it.
Correct. And this usually goes hand in hand with what we call a medical power of attorney. Now, the medical power of attorney, again, is very similar to the durable power of attorney financially. It allows an agent, a designated agent, to make decisions for you. So, and in relation to your medical procedure, so they can authorize surgery. So when would that be important? Because everybody kind of wants to know, like, how does this come into place? So let's take, I don't know if you remember Cedric Benson. He was a running back for the University of Texas, passed away recently from a motorcycle accident.
I do.
All right. He was a great runner, great athlete, went into the pros. I mean, he was really good at what he did. He was on a motorcycle, I'm sure enjoying a lovely ride, was involved in a vehicular accident, and was severely injured. Let's say during that injury, he went to the hospital and he doesn't have the ability to consent for life-saving organ replacement, or plasma injections or whatever it may be. If he had designated or executed a medical power of attorney, whoever his agent was in that document could come to the hospital and authorize these types of treatments. So, those are the kinds of things, especially if it's, let's say it was something that was, I don't want to say experimental, but let's just say, I guess I'll use that word for the moment. Something that, isn't normal in the course of treatment. It's something that has substantial risk. Well, typically they're going to advise you of that type of a procedure before they do it, especially if it's optional. Well, when you're incapacitated, you can't do that. Your agent has the ability to do that if you have one of these types of documents executed.
Yeah, that's a really, really good point because you really probably want to be able to have somebody you trust, obviously, make those decisions for you in the event that you're not able to. And one thing I would remind everyone is that Sam and I both have baby boomer parents, and then baby boomer parents are getting elderly these days, and there's more and more decisions and things like that have to be made. And just speaking from personal experience with dementia and Alzheimer's, that's something that is a lingering illness that lingers on for sometimes years, and with the patient not knowing what's going on and not being able to consent to the most basic things, whether that be financial or with healthcare. So that's where a power of attorney comes into effect. Very, very, very important is if you have maybe a dementia or an Alzheimer's patient, you put them in a facility. You have to make sure their bills are taken care of, make sure they're getting the right medical treatment. It's very, very difficult on the family. And if you put somebody in place that you trust to make those decisions for you, it can certainly ease the burden on a lot of different people.
Absolutely. Not only that, but the financial expense of having to go the other direction. So as an example, let's just play it out. You don't have these types of documents. The unfortunate, scenarios that play out in life happen to you. You're incapacitated in some way, shape, form, or fashion. Well, what does the family do? Well, now they're going to have to chase down a guardianship, which will be a conversation for another day. But just know that those are expensive legal proceedings. What we're talking about is something relatively inexpensive that you can do in advance that really will preserve, and eliminate a lot of expensive legal fees associated with trying to get help in that situation when you do it in advance.
That's a very, very good point, because the guardianships can be very, very costly, very time consuming, and very expensive. So it's something that, these types of documents can help to avoid those situations and avoid ever having to make those decisions. And in most instances, you certainly don't want there to be families becoming estranged over who's going to make that decision. Let's say you have a parent and mom or dad has already passed away. The other parent has already passed away, so they can't make the decision, and it falls to a son and daughter to make a decision. Are you going to have a fight over what type of treatment, or are you going to make the decision? Okay, I'm going to select this person to make my healthcare decisions, and we're going to go from there. So those are where these documents become critical, because you don't want your sons and daughters getting into disputes over what to do, and I'm sure obviously it's difficult on them, and so you certainly don't want them getting into disputes over what the best course of treatment is.
Absolutely, emotionally charged, and everybody loves you, wants to have the best for you, and not everybody can always agree on what that course of treatment will be. So better to plan.
So let's talk next about what happens after you have shuffled off the mortal coil. Let's say you have passed away, and now what's left? Well, we have a will, right?
Absolutely. I mean, a critical piece of every person's life. I try to tell family, friends, clients, if you don't have one, the only person that you're doing a disservice to is your family, the people that you love most. You got to have one.
But let's say I get this question a lot. But Sam, I don't have any real property. I'm not a millionaire. I just have a house and basic retirement. I don't have much.
Even so, a will affords you the opportunity to do two things: specific bequests, right? It affords you the opportunity to be able to say, I have a life insurance policy, even if it's $10,000, $5,000. What do I want that money to go to? Well, I don't want my kids to have to pay to bury me or cremate me or whatever it is that your intentions are. I mean, these are the things. Or I have, hey, I don't own my house, but I rent my house, but I own my furniture. I have TVs. I've got some, things that were important to me. I collect bottle caps, or what I mean. I have a collection of cufflinks like me. They may not be worth a lot, but they were worth a lot to me. And so specifically, I can say, I want this set to go to this individual, because it's a token of who I was that carries on beyond my life. And that's what a will affords you the opportunity to do. Direct your family and friends as to the things that you've accumulated during your life, regardless of value.
And one thing that I would tell you is important is nowadays, with more and more people getting divorced and remarried, there's a lot of blended families. And in a lot of instances, these blended families, you don't treat your stepchildren any different than you treat your regular children. So a will affords you the opportunity to provide for those stepchildren if you so choose. So, and the laws of intestate succession in Texas wouldn't necessarily give you the ability to bequeath anything to a stepchild.
Oh, absolutely.
So
yeah. And it's super complicated. I mean, you get into intestate succession, you talk about levels of sanguinity and, who's going to get by percentage. And it becomes complicated, expensive. And a lot of times goes your estate, the bulk of it or parts of it will go places you don't want them to go. And let's just take Ric Ocasek. I mean, this is a gentleman who had 3 wives, 2 children with each wife. And so in that situation, he's probably got a fairly substantial estate. And even if it's not substantial, he's got the rights to his songs. Maybe he wrote other songs that were never published, that maybe now that he's passing away, there's an interest in the public. You never know what becomes of value in that situation. And so if his current wife is to say, like, everything goes to my children, he may have loved his other children just as much and wanted to pass it, things on to them equally. Well, if he didn't put it in a will, it can really complicate matters.
The other thing would be, obviously, you want to take care of it. If you're remarried, a lot of times you want to take care of a spouse, but you also want to take care of your children. Let's say your spouse, let's say the wicked stepmother doesn't get along with the kids. Sometimes that does happen. So you want to make sure that you provide for your kids and provide for those that are left.
Absolutely. In the case of Luke Perry, let's just use him as an example. This colonoscopy that, basically tipped him off to maybe I have some precancerous growth. He talks to a lawyer, he creates a will that basically guarantees that the bulk of his estate that existed would pass to his children. So he was engaged at the time of his death when he had his massive stroke and passed away. So in that situation, obviously, you don't want it to be tied up. You don't want to have your children have to deal with that situation. But let's say he had just got married. Fresh married, 2 months in, the entire estate, potentially in a community property state like Texas, could pass all to the spouse, completely cutting the children out if you don't have a will. So there's a lot of things that you're going to want to talk to counsel about, talk to an attorney that knows about estate planning to help you kind of guide what to do with your estate if and when, because unfortunately, we are all going to meet, the hand of death at one point in our life. What happens at that point, right? That and taxes.
So let's talk a little bit about what goes in the will, because let's take me, for example. I have young children. Both children are under the age of 18. Do I want them to take my estate and have the world's biggest party at 18 years old, or what do I want to have happen? What can I do to prevent that from happening?
Sure, you can put in trust. Assets that exist in your estate. So whether it be, as an example, you could do, what we call a pour over will, which is you have an insurance policy and the proceeds from that insurance policy upon your death are going to come through the will and create a trust. And so in that situation, why would you do that? Well, let's say, you have a wild child like me, who decided that, all they wanted to do was visit the local, adult beverage establishment and blow any dollar that they could have in their pocket in that place.
Are you talking about jet skis in the pool, Sam?
I'm talking about jet skis in the pool. You know what I'm talking about. And so, the fraternity life, so maybe I wasn't probably the most financially educated individual at the age of 19 to have a tremendous amount of assets, or any amount of assets for that matter, put in my hands to determine what it's going to be spent on and when. Through a trust, you can control that process. You can say, hey, we're going to do this via disbursements quarterly. We're going to give him the bulk of it when he turns 25 or 22 or when he graduates from college. Or there are all kinds of creative things that you can do with assets in your estate, whether it be a fixed asset, real property, or a financial asset.
Yeah, and the other thing would be, obviously, there's appointing an executor, and that executor is responsible for handling the estate and the affairs of the estate. But there's also appointing potentially a trustee that you would need to potentially appoint to manage that money or manage that asset until it's time for the beneficiaries to take over the asset, or for the trust to be dissolved.
Yeah, and it doesn't have to be the same person. Depending on the size of your estate, you can say, hey, you know what? I want this individual to be compensated potentially for the work that they're going to have to do. Because keep in mind that, taking on the role of executor or executrix, female or male, as the case may be, it's a large responsibility. So these are conversations that you're going to want to have with your children. You're going to want to at least make them aware. It's going to be important that you let everybody know where your wills exist. There's a lot of different ways to do a will in the state of Texas, unfortunately. But a valid will, there's only really two. One that's going to be written and sworn to and maintained, and the other one who's going to be holographic, which is complicated and I wouldn't recommend. But, these are things that you need to make people aware of, that they exist. Where are you going to keep them? Keep them in a safe place? Are you going to make copies? How many copies? Where are they going to go? All these are things that are going to be wrapped up in that conversation, Bryan.
And I would tell you that it's better to keep your will at a safe place at your house, most likely, rather than, say, in a safe deposit box. Because if you pass away suddenly, you're going to possibly need a court order to go in that safe deposit box and retrieve that will, which also obviously creates an issue there. So,
well, another thing that people can do, so once you get a will executed to help facilitate that, because people sometimes say, like, well, what if there's a fire? Well, every municipality in the state of Texas has a will bank. And so you can always, get your will executed and keep it on file in the county records in a will bank. Now that has some expense associated with it, but once it's on file, if you ever want to change it, you can. So there's just a lot of things that you can do to ensure that your family doesn't have to deal with those kinds of problems or concerns.
Let's talk a little bit about that. Let's say I have my will. Let's say I get divorced. Do I need to change my will?
Absolutely. Unless you want your ex-wife to get everything. Well, most of the time divorce is going to vitiate those designations. So don't worry, I'm teasing on that. But it's still, so like it creates the potential for an intestate situation in Texas. By intestate, I mean that basically you're passing away without a will. So you have a will, you think it's valid, you get divorced, all the provisions in there relate to your wife. Does it necessarily invalidate the entire will? No. Could it complicate it? Absolutely. Because you may have given her pieces of property that you didn't give anyone else. And if it's not incorporated in the will, potentially it falls to the general bequest, which is all the remainder of my property. But it can make things more complicated. So it's going to be a document that you're going to want to look at and update periodically.
And let me talk a little bit about intestate succession. Intestate succession laws in Texas can be very complicated because you first have to classify all the property, then you have to determine whether it's separate or community property, then you have to determine who gets what share and how much of those shares go to each person. And that can be, if you have a small estate, and especially if you have a small estate, that can be a very time-consuming and expensive process. And you really, really don't want to have to do that, and you don't want to have to throw up your hands or have your family members throw up your hands, after you pass away, and because they can't deal with a court proceeding that deals with intestate succession. Because, a will can be for a small estate. It doesn't have to be, Ric Ocasek money or Gloria Vanderbilt money or anything like that. It can be a smaller estate. It's like Sam said at the very beginning of this podcast, it's really for those that are left behind. It's basically to kind of preserve your legacy and make sure it goes to the people that are left behind.
Without a doubt, Brian, without a doubt.
And do we have anything else you want to add to this?
No, I think we've talked enough about the hand of death. I think next episode will be cheery.
Yes, let's hope we can be a little bit more cheery. Maybe we'll talk about adoptions or something like that, something fun. But to be a little bit more serious, it is important for you to sit down with your attorney and talk about this is my estate plan, this is what I want, and like Sam said, it doesn't have to be huge assets. Like it can be a cufflink collection, it can be a sword, it can be family heirlooms and stuff that gets passed down from generation to generation. It's it can be very important personal property that you may want to stick in that will. So it's not just about dividing up houses and ranches and all the big stuff. And keep in mind that lots of things like life insurance have beneficiary designations on them. So you may want to look at your life insurance and see who the beneficiaries are and see what the potential beneficiary plan is, because you may want to put that into your will because it may be more beneficial to you to put it into a trust or something like that. So those are all things that an attorney, a competent attorney in these areas can help you with.
I couldn't agree more, Brian. I just want everybody to understand how important it is that in your life, no matter what you accumulate, that you sit down and generate a will. Talk to an attorney, have somebody put it together, whether it's personal property, small estates, massive estates. If you don't have one, you're doing a disservice to the people you love most. And
the other thing is, you can do a lot of things to help with tax planning and debt planning and different things like that through these estate planning vehicles. And like Sam said before, not just the will, but with the powers of attorney, you can make sure that decisions you want made are made the way that you want them. And nobody likes to talk about these subjects. And it's funny that some of the wealthiest and some of the most educated people in the world don't have wills and stuff like that, because it's not a subject that people like to talk about. But it definitely is something that is necessary. It's definitely something that is helpful to people.
Couldn't agree more.
All right. Well, I think that will wrap us up for today. I really appreciate your time, Sam. And we will talk at you next time, and where we will cover a topic that hopefully is bright and cheery.
Catch you on the flip side.
All right. Take care. Thank you for listening, and we hope you enjoyed the Top Texas Lawyers podcast. If you would like a consultation with either Bryan or Sam, please call 1-888-981-7509 or visit us on the web at astxlegal.com. Once again, that's astxlegal.com. Thank you very much.